Finally, it may also be useful if it's made explicit that the stipulations in Clause 4 apply to donors who do so in good faith. In particular, I would suggest that line 19 of page 5 consider the inclusion of this term so that it would read a food donor who donates any food in good faith shall not in fact be liable, and so on. Now, also observe that this is not the first time that questions concerning Good Samaritan acts have been discussed in Parliament. This occurred on 4 prior occasions in 2008, 2012, 2014 by former PAP MP Associate Professor Fatima Latif, and more recently in 2021 by the Honourable Member Hazel Phua. To be clear, on each of these occasions, the then Ministers of Law explained that such legislation was unnecessary since both civil and criminal liability would generally be waived for those acting in good faith. And it was stated explicitly that our current laws strike the correct balance. Granted, the context for those Good Samaritan discussions was distinct and applicable more to the provision of on-site physical or medical assistance to those in need. Importantly, such laws in many other jurisdictions actually compel aid, whereas the bill in question today is essentially voluntary in nature. Still, I believe it's fair to ask why this particular Good Samaritan law, which waives liability in a voluntary context, is deemed necessary, while an analogous law that would do the same for involuntary harm is not. Importantly, I think it's useful for us to put ourselves in the mindset of those rendering aid. Would their knowledge of the potential for liability inhibit their choice to render succor, even if the law would not explicitly hold them to account? Would it be better to have the waiver made explicit, as it is in this present bill, albeit in a different context?
Mr. Speaker, I had not actually intended to speak on the bill, but this is more of a clarification in response to a few points raised by Associate Professor Jamus Lim. Associate Professor Jamus Lim had made a few observations regarding the bill and statements by various ministers for law in response to questions, and I was one of those at that time, Senior Minister of State for Law, who had addressed a question on the point of Good Samaritan bills. I believe Associate Professor Lim asked why this particular Good Samaritan law is deemed necessary when an analogous law that would do the same for involuntary harm by a helpful bystander would not. And actually, the answer, if you had listened to his speech, is actually answered by Associate Professor Lim himself. He had said this, and I quote, "Granted, the context of those Good Samaritan discussions was distinct and applicable more to the provision of on-site physical or medical assistance to those in need. Importantly, such laws in many other jurisdictions compel aid, whereas the bill in question is essentially voluntary in nature." And that is exactly right. In short, the context of the previous parliamentary questions and the replies to them is different. The previous questions, or PQs, refer to Good Samaritan laws in the context of rendering medical or emergency assistance to people who are ill or injured. For example, in his reply, Professor Jayakumar explained that Good Samaritan laws adopted in other countries broadly take 2 forms. First, to reduce bystanders' hesitation to render assistance because of significant liability concerns. In these jurisdictions, there are laws granting persons who offer aid in emergency situations certain protections from legal liability. And second, to impose a positive legal requirement on people to assist others in distress unless it will put themselves in danger. On the first point, that is, to overcome bystanders' hesitation, the various ministers for law explained in their replies that in Singapore, we have not encountered reluctance on the part of our citizens to step forward to help in those emergency situations. And on the second point, Professor Jayakumar said that helpful bystanders do not face any major liability concerns in Singapore. For civil liability, a person who offers assistance need only comply with what is expected of a person of his or her skills or experience, so an untrained person would not be held to the standard of a doctor, for example. As for criminal liability, that is generally premised on an intent to cause harm or injury. A person who has acted reasonably and in good faith is unlikely to be held criminally liable. As such, In the context of rendering emergency assistance, it is MinLaw's assessment that there's no need to introduce a Good Samaritan law, though MinLaw said that it would continue to study the experience of other jurisdictions and would review our position if the need arises. The context of the current Good Samaritan bill is different. First, it deals with food donations, not emergency medical services. The considerations are different. And second, as I understand it, Mr. Ng is moving the bill because potential donors are hesitant to donate because of potential liability concerns. And this is different from the emergency scenarios addressed by the Ministers for Law, where they had not encountered reluctance to step forward and there are no major liability concerns. Thank you.
I thank the Minister for the clarification, which I truly appreciate. If I could clarify, since Minister did suggest that she had spoken about this Good Samaritan laws elsewhere before, do all other jurisdictions compel the rendering of aid? Are there some Good Samaritan laws that simply waive liability? And I ask this because in that case, then analogous to this law, the idea of providing that peace of mind to bystanders that may choose to render aid, I think would nevertheless still be helpful.
I thank the member for his clarification. I had actually addressed that earlier because he asked whether all jurisdictions compel them to provide aid. And as I had explained, which was also explained by Professor Jayakumar, there are two forms. Firstly, there are some jurisdictions where you have it because you want to reduce hesitation. So in other words, it's because people are reluctant to step forward and help. And in some other jurisdictions, they take a more aggressive approach and they say you must help. But of course, having said you must help, then the corollary is you also provide the waiver of liability. So in short, there is no one size fits all. You have a law where there is need, and or you assess that you want to do it for a particular reason. In this case, this bill is a private member's bill. The need, as I understand it, is Mr. Louis Ng feels that people are hesitant to donate because they are concerned about liability. The context of the Ministers of Law talking in the emergency medical assistance context was there isn't a need because people are not hesitant to step up, number one. And number two, there's no major concern about liability because our law pitches the liability at your level of skill or expertise. So if you're a doctor, you're held to a higher standard. If you're just, ordinary person helping out, you're held to that standard. So the considerations are different.
One final clarification.
I promise to be quick. Just one note, and that is that I don't think we can actually know if it's true that someone who is hesitant has not actually hesitated to step up, right? Because we don't observe all those individuals that have stepped up. So I'm wondering if the Minister will agree with me that indeed we will never know the counterfactual to this situation.
Assc Teo.
Mr. Jamus Lim may have missed the reports in the newspapers from the last few days. I was present at the Home Team's National Day observance ceremony at the Home Team Academy. And there were dozens of members of the public who had voluntarily stepped forward in emergency situations to help others. So perhaps Professor Jamus Lim, Mr. Jamus Lim, would like to look at those news reports and look for himself. Thank you, sir.
Minister Indranee, would you like to respond as well?
I'm sorry, sir, because I was listening to SM and I'd forgotten Professor Lim's question. Would you like to repeat it?
The question is whether it's not so much whether we observe that some people are indeed stepping forward. I'm certain that's the case, and we have news reports that say this. My question is, what we do not observe is all the instances where people have chosen not to step forward because of fear of liability. That is fundamentally unobservable as a counterfactual, and that's why I asked whether you would agree that we would not know the full extent to which individuals have not stepped forward.
Senior Minister Teo.
Sir, perhaps instead of debating this issue in a theoretical manner, look at the practical issues, Mr. Lim. Perhaps Mr. Lim would join me in encouraging members of the public to do so, rather than debating this in a theoretical manner. If all of us encourage members of the public to do so and tell them not to be afraid, I'm sure they will do so, and more of them will do so and not be hesitant.
Minister Indranee. Mr. Speaker, I don't think I have more to add to what SM Teo has said, other than the fact that you take the assessment based on what you see, and if we don't see that there is a particular need, then there's no need to pass a legislation or move a bill. But SM's point is perfectly well taken, which is that it is good to encourage people to step up.